Progressive Era, Part 2, The Nadir of Black Existence. On the night of August 13th, 1906, in the town of Brownsville, Texas, shots were fired that ended up killing a white bartender and wounding a police officer in the town. Suspicion was immediately cast upon black soldiers from the 25th Infantry stationed at Fort Brown nearby. Those soldiers made up an all-black infantry, and in 1906 they lived under the customs of the time, separate but equal conditions, frequently subjected to racism and inequalities of all different manners. There had been flare-ups and tension in the past, and just in the weeks preceding this shooting, there had been other violence between whites and blacks in the town. With that said, there was no evidence that the black soldiers from Fort Brown had anything to do with the shootings of August 13th, despite the claims of some of the townspeople. Gunshot shells that were found at the scene are more or less accepted by historians now to have been planted by the townspeople, and white officers at Fort Brown supported the thought that all of the black soldiers had been in their barracks that night. At the same time, under the largely racist Southern rule of the day, the soldiers were nonetheless prosecuted for the claim, and ultimately Teddy Roosevelt, the president of the time, was called in, and he ordered that 167 of the black soldiers be dishonorably discharged. Whether or not they were involved in the crime, it was his belief that they had not supported the investigation. A number of these soldiers were medal recipients, and none of them are believed to have been involved in the attack. Despite pleas from Booker T. Washington and others at the time, and much evidence supporting the innocence of the soldiers, Roosevelt did not back down from his decision. It was not until the 1970s, when the case was reopened, that the soldiers were in fact ruled innocent and their dishonorable discharges revoked, and they were granted honorable discharge at that point. Unfortunately, of course, almost all of those soldiers were at that time dead. There was only one still living at the time, and he was given some compensation. This event illustrates one of the most telling shortcomings of the Progressive Era, and that is in the realm of race relations. While many other elements of American society and social welfare were moving forward, in the realm of race relations, the country was still mired in the midst of what some historians consider the nadir of black existence, the worst period in African American history. While it may be difficult to make the claim that this period was worse than slavery itself, there are some historians who do make that claim because, as we've mentioned a number of times already in this course, the idea that freedom was dangled at the fingertips of African Americans and yet so frequently revoked, and that blacks, while they were technically free, were still subjected to so much racism, so much inequality, violence, intimidation, and so on, that in some ways it may have been worse than slavery. So this is the subject for the remaining part of this lecture, the so-called nadir of black existence, the low point of black existence. How can we argue that, in fact, this was the lowest point in African American life in this country? Well, there are a number of different elements of society that we can look at as evidence of this. One of them being political representation, specifically the right to vote, the right to participate in the political process. You might recall that we've got the 13th Amendment, 14th Amendment, and 15th Amendment, the so-called Reconstruction Amendments, abolishing slavery, establishing citizenship rights for the freedmen, and securing the right to vote. As I mentioned briefly at that time, however, by the end of the 19th century, whites had found many ways around these rights and had found many ways to deny blacks the ability to vote, even if technically they did have the right to vote. And so we'll talk about several of these things now. Collectively, the process of denying blacks the ability to vote was known as the Mississippi Plan, while many of the different schemes and measures we're going to talk about applied broadly across the South and even in other parts of the country at times. Most of them originated in the heavily racist state of Mississippi, and thus we call it the Mississippi Plan. What kinds of things could whites do to deny blacks the ability to vote? Well, one of the things that was broadly applied across the South was a poll tax. Yes, you might have the right to vote, but when you show up to vote at the polls, we're going to charge you. Something else that might be done were literacy tests, or what was sometimes called the understanding clause. Okay, you have the right to vote, but when you show up at the polls, you're going to have to take a brief test. And as you've all discovered throughout your experience as students, and perhaps even students at Lander University, testing is in some ways in the hands of the tester, the person administering the test. And so if a white voter showed up at the polls, they had to take the same kinds of tests, but the tester might just say, okay, sign your name or just put an X on this page and you can go vote. And then a black voter following behind in the line would be handed a complex portion of the United States Constitution and asked to interpret it for the person giving the test. So these were some very effective measures in denying blacks the ability to vote, even if they did technically have the right to vote. At the same time, these laws applied to poor whites as well as poor blacks. And particularly with something like a poll tax, poor whites were a little better off than blacks at that time. And so they might be subject to those restrictions. That could be very frustrating. Literacy tests, as I said, they were in some ways in the hands of the person giving the test, but it also was an inconvenience for poor whites. And so whites who were in power began to channel the anger and frustration of those poor whites and essentially blaming blacks for the kinds of inconveniences that poor whites were struggling with. We can refer to this as race baiting. It was a very common tactic, especially in the South in this era, and led to poor whites having an even greater hatred for blacks. You see in the picture below an example of one of these poll tax fees that had to be paid at that time. And on the right there, this cartoon, sort of an ironic reflection on the thought that blacks were going to have to pass a literacy test or an understanding test when very clearly many whites were no better educated than blacks. If poll taxes and literacy tests were effective in limiting the ability of blacks to vote, there were still other ways in which southern states limited their political representation. Another policy that was applied broadly in the South were residency requirements. You had to demonstrate that you owned property if you were going to vote. And as we've talked about, and I'll mention again briefly, most of the blacks in the South, the great majority, were still living under sharecropping and didn't own their own land. Of course, here's another idea that also roped in poor whites at times into this scheme. And so the state of Louisiana came up with yet another creative way to exclude blacks while including poor whites. It was known as the grandfather clause. And what this clause did was it established the date of January 1st, 1867, which was the date that the 15th Amendment went into effect. Remember, that gave blacks the right to vote. And what the Grandfather Clause said was that if you had the right to vote prior to January 1st, 1867, then you would not have to meet any of the other requirements, such as the poll tax or literacy test or things like that. Well, of course, this basically means if you are white, because you would have had the right to vote before January 1st, 1867. And Louisiana even said if you had the right to vote, or if your father or even grandfather had had the right to vote at that time, then you were exempt. And this ensured that for several generations into the future, these restrictions would only apply for blacks. As if all of these measures weren't enough, there was a final technique that was applied in many different places, and that is gerrymandering. This is something we still have issues with in some places today, and you might know what it is, but the cartoon there on the right gives you some idea of what gerrymandering is. It simply means that the borders of a particular voting district are drawn in sort of creative ways to include or exclude certain parts of the voting population in a particular district. And so what they might have done under this sort of idea is redrawn the voting lines of a district that might have had many black voters in this district. Well, they might just extend it out in an odd sort of way in one direction to tie in a very large, heavily white populated city. And so those white votes would have overwhelmed whatever black votes might have come in. And so this is a final way to essentially exclude blacks from the political process. And with so many of these measures stacked up against them, as we move deeper into this period of the 1870s, 80s, certainly 1890s, the black vote, particularly in the South, is essentially meaningless. They are completely removed from the political process. These kinds of discriminatory practices and segregationist ideas were applied in custom broadly across the South and other parts of the country for many years prior to 1896. But it was the Supreme Court decision in the case of Plessy versus Ferguson in that year, 1896, that cemented these kinds of ideas not simply as a custom, but as the official law of the land, upheld by the Supreme Court. The case of Plessy versus Ferguson ranks as one of the most important decisions in the history of this country. Some might argue the most important decision in this country. And it installed the idea of separate but equal, the famous doctrine of separate but equal, which would govern the nation up until the Brown versus Board decision in 1954. So what happened in this case, Plessy versus Ferguson, the incident that led to the court case itself occurred on June 7th in 1892 in the city of New Orleans. And New Orleans had a law at that time that mandated separate rail cars. You might be familiar with the trolleys of the city of New Orleans, some of which still run today. And so they had separate cars for white and for black passengers. You actually see a picture there at the bottom that gives some idea of what we're talking about. One car for whites and one for blacks. Homer Plessy, in the interest of testing this law, intentionally boarded the white trolley car, and he was asked to leave by the conductor of the trolley, whose name was Ferguson. Plessy is arrested. He is convicted under this law, and over a handful of years, his case made its way on appeal up through the courts, and ultimately in 1896 reached the Supreme Court. And the Supreme Court, in its decision, upheld the constitutionality of Louisiana's law, mandating separate rail cars for white and black. This becomes the famous doctrine of separate but equal. As long as the facilities and accommodations are equal, then it is constitutionally allowable that they be separated for the two races. This was nearly a unanimous decision, but there was one dissenting opinion, and that was from Justice John Marshall Harlan, who wrote a very eloquent dissent, and so his words and opinions were published alongside the official ruling of the court. And we look back at Harlan's words as predicting the sad realities of what were to come over the following decades. So I'll read just a portion of Justice Harlan's dissent. May it not now be reasonably expected that astute men of the dominant race, who affect to be disturbed at the possibility that the integrity of the white race may be corrupted, or that its supremacy will be imperiled by contact on public highways with black people, will endeavor to procure statutes requiring black and white jurors to be separated in the jury box by a partition, and that upon retiring from the courtroom to consult as to their verdict, such partition, if it be a movable one, shall be taken to their consultation room, and set up in such a way as to prevent black jurors from coming too close to their brother jurors of the white race. So just to sort of translate that, I know the legal tone is a little thick. Can we not assume that white men who are sort of pretending that any contact with blacks, imperils the integrity of their race? Now they're going to require that jury boxes be segregated, and that the consultation rooms are going to be segregated. And we can read into Harlan's words, taking this forward, that water fountains will be segregated and waiting rooms will be segregated and rail cars and everything else in society will be segregated. And in fact, that is exactly what transpired beginning in that era and over the next 50 to 60 years. We know this as the Jim Crow era, an era in which segregationist laws applied extensively in the South, but even in other parts of the country as well. And we become a very heavily segregated and separate society. With Plessy versus Ferguson on the books and racist laws now constitutionally upheld by the Supreme Court, we see a cascade of similar laws being passed throughout much of the country. These are the Jim Crow laws that govern this era. Just as a few examples, in 1905, a Georgia law mandated separate bank facilities for white and black customers. In 1915, Oklahoma mandated separate telephone booths for white and black. And in New Orleans, there was even a law requiring separate prostitutes for white and black customers. These laws even extended into death and beyond, as many cemeteries segregated their facilities as well. So the idea of separate but equal is installed, but as we all know intuitively, while the nation mastered the idea of separate facilities, they were never really equal. It's not always easy to judge, although while we know intuitively that black facilities were inferior, it isn't always easy to tell. But the chart on your screen is one way that we can actually quantify and demonstrate that black facilities were inferior. This is just one measure, but it tells you the dollars spent per student. The different bars in green are for white students, and the different bars in purple are for black students. And you see the sort of lighter bar on the left in each case is pre-Plessy versus Ferguson, 1890, and the bar on the right is post-Plessy versus Ferguson, 1910. So if we look at Alabama, for instance, as one example, the lighter shaded bars before Plessy versus Ferguson for black and white students appear to be exactly the same, or very close to the same. After Plessy versus Ferguson, the bar for white students is, 3 or 4 times higher than that for black students, meaning that in terms of dollars spent per student, the state was spending perhaps 4 times as much on white students than they were on black. And you see in every other case, if you look at North Carolina as well, before Plessy, the lighter shaded bars are almost exactly the same. And then after Plessy, we see it looks to be about double the dollars spent on white students. And in every case, there is some degree of this relationship. This is just one example. And again, it applies across society that while facilities are separate, white facilities almost always are going to be superior to black. Well, how else can we explain that this period represents the nadir of black existence, the low point? Well, another one is the continuing prominence of the practice of sharecropping in the South, which I described in the previous lecture about Reconstruction. Blacks being tied to the land, in some cases the same land that they had been living on under slavery, and unable to break free from this process. As of 1900, about 90% of the black population in the country was still living under this idea of sharecropping in the South. And of course that means about 10% had broken free in one way or another, living either in the West or in the North. By 1910, the number is still about 85% of the black population. So you see another 5% or so breaking free. So while we cannot say this is unanimous and that all blacks were trapped under sharecropping, even about 50 years after slavery is over, still 85% of blacks are living under sharecropping. So progress forward was very slow. Most of the blacks are trapped under the idea of what we call debt peonage. It's almost a pseudonym for slavery. They are legally bound, they are legally trapped under this system because, as I described to you earlier, they find themselves 1 year slipping into debt as determined by the landowner. Remember, it's the landowner who counts up at the end of the year and determines how much the sharecropper is to be paid, or in fact how much they owe. And if they were found to owe money, they legally could not leave that next year. And so many, many thousands of them find themselves year after year after year tied to the land under debt. And so again, I would just remind you that there is 10%, 15%, very slowly moving forward, who do escape from this system and do manage to own their land. There are always exceptions. Even going back under slavery, there are free blacks, there are professional blacks, there are a handful of wealthy blacks. There are always exceptions. But when we speak in terms of the great majority, they remain trapped under this system of sharecropping.